SP 106-84961, SP 1111617, counts 1, 2, and 3, SP 11116371, SP 1129810, counts 1 and counts 2, SP 1389565, counts 1, 2, and 3, SP 9644961, 22737166, counts 1 and counts 2, and 227371. Appearance for the record, please.
Good morning, Your Honor. Tana Jenkins on behalf of Mr. Lucas. Mr. Lucas, please place your full name on the record.
Nathan Daniel Lucas, a living man.
A living man?
Yes, sir.
I would think that would be obvious, right?
No, sir. Not in the etymology of the courts and the syntax grammar. No, sir.
You've gone above my head on that. I can't. That's above my pay grade. All right. So are you interested in a lawyer representing you, sir?
No, sir.
Okay. Are you interested in even getting a driver's license?
No, sir.
Are you interested in an offer at all?
No, sir.
Set the matter for trial.
Well, I intend to plead in the form of a demurrer, such that I do not acquiesce to quasi-jurisdiction.
I didn't see any pleadings filed with the court. Do we have anything?
I said that is an issue to be brought up. My pleadings to be briefed and filed with the court.
Well, you should have done that. Today is the date and time set for arraignment on the bench warrant. Kind of here. I'll enter a not guilty plea on your behalf, sir. Give you a $0 bond, and I'll set a trial date for November the 14th, 2024. Or if you want a pre-trial date to file some pleadings, I can set that for October 21st, 2024. Which one would you like?
You could repeat that, sir.
Pre-trial date, if you want to file some motions, pre-trial date will be October the 21st, 2024. Or
that will be fine.
Just set it that you want that date?
October 24th, 2024?
October 21st.
21st.
2024 at 8:30 a.m. All right?
Yes, sir. And just for the record, I did not enter in no plea. I don't plead.
All right. Well, I'm entering in for you. All right. Have a good day, sir. I'll see you back October 21st, 2020.
All right. Today, we're diving into a sea of sovereign citizen courtroom moments that perfectly illustrate what happens when internet legal theory collides with actual judicial authority. We've got multiple defendants, multiple courtrooms, and one recurring theme: people who believe they've discovered loopholes that somehow override decades of established up. We're heading into Judge Perkins' courtroom, where a defendant proudly identifies himself as a living man, as if the court was under the impression he was appearing as a hologram. From there, we move into a far more serious situation: a defendant who skipped court, rejected mail from the court in red ink citing federal statutes, and now faces an absconding charge because he believed he could simply opt out of if that wasn't enough. We're closing out in Georgia with two more sovereign-style arguments, this time layered on top of felony probation issues. These aren't minor misunderstandings. These are decisions that directly impact bond, custody, and potentially you're about to see is a consistent pattern: misunderstanding jurisdiction, rejecting procedure.
All right. And all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
Ward Skittish, Wayne County Prosecutor.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter. So
I do see that the new charge is set for an arraignment on September 10th it was at 10 a.m. You want us to continue this to the same date and time?
Yeah, Your Honor, that'd be fine.
Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his wife and children. He's obviously no longer listening to outside forces and taking back.
And here we go, the classic sovereign citizen introduction, a living man. This phrase gets used constantly in these cases because the theory suggests that courts only have jurisdiction over a corporate legal fiction version of a person, not the living man. The problem? Courts have heard this argument thousands of times, and it has never successfully stripped jurisdiction in a criminal Judge Perkins reaction. It's not anger. It's not confusion. It's mild bewilderment followed by moving on. That's important. Judges don't debate metaphysics. They move cases the moment he says he's not interested in a lawyer, not interested in resolving the license issue, and not interested in an offer. That's where this stops being philosophical and starts becoming procedural. The court now has to treat him as someone proceeding on his own.
Incarceration and his sitting in bond being revoked. To my understanding, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had a lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you, Ms. Gitters. People's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right. Well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to represent, when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender, 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a...
This is another familiar move, invoking terms like demur and quasi without filing anything in writing. A demur, in jurisdictions where it's recognized, must be properly drafted and submitted. Not casually referenced during a T's critical here is timing. Today was set for arraignment on a bench warrant. That means the defendant previously failed to appear. This isn't the moment for abstract jurisdictional theory. It's the moment to enter a plea so the case can move. The judge says he didn't see any pleadings filed. That's not a technicality. Courts operate on record. If it's not filed, it then comes the key moment. The judge enters a not guilty plea on his behalf. That's completely within judicial authority when a defendant refuses to plead. The case proceeds scripts assume silence equals resistance. In court, silence just means the judge decides.
And an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court, court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLeod respects the authority of any governing authority and that he would appear. He's refused to appear and now has an absconding charge. So,
all right. Mr. Whitlock, you have appears to be duplicate charges. So some of these charges are going to be dismissed and you have two separate incidents. Because you're on active probation for the felony charges, I cannot provide you bond. So for the aggravated assault on police officer, fleeing a police officer, and for the obstruction felony charge, there will be no bond. For the theft by taking, that'll be a $1,000 charge as a misdemeanor. For the second incident, there is a no license charge, which is being dismissed because there is no facts to support it within the warrant. The tinted window will be $500. Use or possession of drug-related objects, $1,500. Identity fraud, no bond. Crossing guard lines, 2 counts, no bond. The wanted person charge is going to be dismissed because that's something separate totally from this incident. And giving false name or address or date of birth will be dismissed because there are no facts to support it in the warrant. So again, you have 2 counts of aggravated assault. One of those is going to be dismissed because there appear to be duplicate incidents. 2 counts of fleeing an officer. One of those is going to be dismissed. But at this time, there's no bond, which I can confirm which one's going to be dismissed. You'll have a minute to ask your question, Mr. Whitlock. I'm not done. The theft by taking misdemeanor, 2 counts, $1,000, and the obstruction of an officer is no bond. Your preliminary hearing is currently set for September the 9th at 8:30 a.m. In regards to court-appointed counsel, Mr. Whitlock, are you working? Did you want to be considered for a court-appointed counsel?
Oh, no, I don't want court-appointed counsel, but I do not proceed to I do not.
Hold on. So you're going to hire your own attorney?
Yes, ma'am. I don't consult to the proceedings and.
Now we move in a much more serious territory. This isn't a traffic issue or licensing matter anymore. This is a defendant who failed to appear, had a bench warrant issued, and was physically picked up by Law Critical because once a warrant is executed, jurisdiction is undeniably established through lawful custody. The "you don't have jurisdiction" argument becomes almost meaningless at that. Now there's an absconding charge, which typically stems from intentionally avoiding court supervision or bond conditions. That escalates things. Makes this even more consequential as bond. Bond is built on trust that the defendant will appear and comply. Once someone
I know, but that don't say I'd rather be charged for that than when they're putting on me. They found that on a water fountain. I don't even know what a water fountain is. I was with the officer the whole time. Even the officers in there said, man, this is gonna get thrown out because the officers were just being an a-hole and putting everything on me. I had none of that. I was with the officer the whole time. You could tell them.
Mr. Whitlock, this is not a hearing. I don't have the officer here. So when we have the hearing, all this can be brought forward for your preliminary hearing or for, your attorney who you hire who can help you negotiate this. Again, I'm advised this is not a hearing. This is just to tell you what you're charged with. So any other questions?
If I say I do not consent with you for proceedings though, and I do not accept the terms, like.
Okay.
Yeah,
well, you can discuss that with your attorney. If you have no other questions or comments, you're free to go.
Now, this one more question, man.
Okay.
That with what you was just charging me with, that had been in College Park. So is that a part of y'all?
College Park is in Clayton and in Fulton, sir.
Yes, ma'am. So I'm wondering, I thought I had to deal with Fulton County on that instead of Clayton.
Looks like you have some Fulton charges as well, so.
Yeah, but the Fulton County charges is someone else. That's the way they actually locked me up and then let me out the hospital once he found out it wasn't me. So why they're still on me? Like
This charge, let me just tell you, the charge that you're for the aggravated assault that was in College Park, it is on or around July 28th, it happened. So that is not the Fulton County one that appears to have happened around July 17th. So there's
Clayton County.
Yeah, the warrant was sworn out for Clayton County, yeah.
Okay, ma'am. That's all I was asking. Because I know that's gonna get handled. That's some BS, but all national. I have 2% in the legends. The man even told him, hey, yes, he owner, he's an owner. And they still, hey, let me search you and all that. Now, once they searched and seen, I was clear, good. I know the officer, I buy them food. And the dude that was in, I also rent cars out. I have a Maserati truck I was renting out at the time.
Mr. Whitlock, I'm gonna stop you there, because you're doing too much. You're talking about Fulton County. I was trying to let you go forward and explain.
I need some professional help, like.
Okay, well, you said you're hiring your own attorney, so they'll be able to help you with those charges, sir. Good luck.
I'm gonna have an attorney for the charge, but since you're a judge, you could tell me, like, why did they let me go? They let me go.
I can't tell you what happened in that case. I don't have those facts before me. I only have the ones I'm dealing with right now. So you're free to go. Thank you.
So what's my bond?
You have no bond because you're on probation.
I heard you give me a couple of numbers also.
There was for the misdemeanors, there's like $1,000 and $1,500 for the remaining felony charges. Those statutes don't allow a judge to give you bond if you're on active probation for felony charges.
Yes, ma'am. But even in Fulton County, they don't allow.
It's the laws of Georgia, yes, sir.
Okay. I thank you, ma'am.
You're welcome. Have a good day.
That advice. That phrase gets used a lot in these cases. But here's the reality. Courts don't revoke bond because someone watched the wrong YouTube video. They revoke bond because someone failed to appear, rejected official court correspondence, and then had to be as something important. He had previous counsel. He wasn't abandoned. He wasn't uninformed. He actively chose to reject court mail, physically writing federal criminal statutes on it in red ink and sending a BS, not confusion. That's AD is conditional liberty. When you show the court, you won't acknowledge its authority.
I'm asking you.
Your Honor, his name is Tyrese Breland.
Breland? That's not my name. Oh, Breland. That's not my name. I'm here on special representation.
Same as last defendant, Your Honor.
My Honor, I'm asking. Okay. What is your status and what is your name? I'd like to know your name. I'd like to know your status. Of everyone in the courtroom, I would like to know what is your nationality and what is your
deputy.
Yes, ma'am.
I would like to know your nationality.
He has charges in JOTS and he has a paper charge. Let me see if they're the same warrant. And they're different warrant numbers. Okay. So I guess I do both sets. Let me see when these are.
Know your nationality. I would like to know if you're a U.S. citizen of the United States. And so what is your status? You're a U.S. citizen of the United States?
All right, hold on one moment, sir. Let me review the warrant.
I'm asking you for your status and the status of everyone in the courtroom. I would like to know your name. I would like to know the nationality. I would like to know, are you a U.S. citizen? Once again, my honor.
Is he deputy?
Status of everyone in the courtroom.
Is he injured? Is that why why is he in a wheelchair?
Yes, ma'am.
I would like to know the status of everybody in the courtroom. I would like to know your name. I would like to know your nationality. I would like to know are you a U.S.
This moment right here is the crux of sovereign ideology colliding with criminal procedure. The idea that a criminal case is some form of optional contract that can be rejected by writing return to sender misunderstands the fundamental nature of